So you sign a contract and you figure you know exactly what you're getting into, right? I mean, it's all there in black and white. But what if I told you that sometimes a simple conversation, a spoken promise, can actually be more powerful than the written word? We're about to look at a case where that's exactly what happened, with some pretty disastrous results. All right, let's set the scene. Our story kicks off with what seems like a totally standard business deal to ship some goods. But lurking beneath the surface of this simple arrangement were two completely different agreements, pulling in opposite directions. And that tension, it led to a total disaster and a really fascinating legal showdown. Okay, so on one hand, you had the official signed written contract. This thing had a clause that basically said the shipping company had discretion over how they handled the goods. In plain English, it gave them the freedom to make their own judgment calls on how to best get the job done. But, and this is a big but, there was also a verbal promise, a conversation. The client was absolutely clear. They insisted their cargo had to be transported below the ship's deck. No exceptions. And the company? They gave their word. So what happens when that container gets loaded onto the top deck, it falls overboard, and it's lost forever to the sea? Which promise wins out? Is it the written contract that gave them freedom to choose, or is it that very specific verbal promise? That's the million-dollar question we're about to answer.
To really get how a court would even begin to untangle this mess, you have to understand something crucial about contract law. Not everything that's said during negotiations is created equal. No way. There's a definite hierarchy, kind of like a legal ranking system for promises.
It all breaks down into three basic levels. At the very bottom, you have what's called a puff. Think of this as marketing fluff. Then you step up to a representation, which is a lot more serious. It's a statement of fact that convinces you to sign on the dotted line. And at the very top, the king of the hill, is the term. That's a promise so important it becomes part of the contract itself. Let's make this super clear. You know the slogan, Red Bull gives you wings? That's a perfect puff. It's just a fun, vague marketing claim. Nobody's suing because they can't actually fly, right? But a representation is totally different. That's more like someone telling you a car has a specific engine or a product is made from a certain material. It's a factual claim you rely on. And then we get to the term. This isn't just a claim. It's a core promise. It's woven right into the very fabric of the deal. And here's why it's so important. If a term is broken, it's not just a minor issue. It is a full-blown breach of contract. And that's when you can sue for damages. So this all leads to a really interesting puzzle. How do the courts decide which of the dozens of things said during negotiations actually become these super important binding promises? Well, it turns out they're looking for one key thing, the true intention of everyone involved. You got to put yourself in the judge's shoes. They have to sift through all this pre-contract chatter, the emails, the phone calls, the meetings, and their job is to figure out what was just talk and what was meant to be a rock-solid, legally binding part of the final agreement. When they're trying to figure all of this out, it really just boils down to one word, one idea that's more important than anything else: intention. What did these people actually intend for this promise to be? Was it a casual assurance, or was it meant to be an unbreakable rule of the deal? Okay, so let's get back to our story, the cargo lost at sea. This was a real case, by the way, from 1976. It's called J. Evans & Son, and it is the perfect example of how the courts go on this hunt for true intention. And here it is, the core conflict, laid out as clear as day. On one side, the written contract says, hey, you guys have discretion. But on the other side, you have that very specific, very firm verbal instruction. The goods must be below deck. You can see how they're totally at odds with each other. And because the shipping company chose to follow the flexibility of the written term instead of the specific oral promise, well, the worst possible thing happened. The cargo was lost, and the client sued, claiming not just negligence, but a direct breach of their contract. So how in the world did the court figure this out? Now, they could have just looked at the paper, pointed to the discretion clause, and said, case closed, but they didn't. They did something way more interesting. They looked at what they called the holistic set of circumstances, the big picture, the entire context of the deal, including every single conversation. And the verdict? It was a bombshell. The court decided that the oral agreement, the promise to ship the goods below deck, was so important that it was officially incorporated into the contract. It was a binding term, and by putting that container on the top deck, the company had broken their contract. That spoken promise was just as powerful as the ink on the page. This case teaches us such a powerful lesson. A contract isn't always just the paper it's printed on. The real deal, the true agreement, is often shaped by all the conversations, all the promises, and all the intentions that surround that document.
So let's break this down. What are the big things you need to take away from this? First, a contract is like an iceberg. What's written down is often just the tip. Second, those verbal promises you make, they can absolutely be legally binding. Third, courts are going to look at the whole story to find out what you really meant. But, and this is so important, the absolute safest, strongest proof of a promise is to get it in writing. That's your ultimate protection.
And that leaves us with one final crucial question to think about the next time you're about to make a deal, whether it's big or small. Are you just looking at the words on the page, or are you thinking about the entire agreement, spoken promises, and all? Do you really know what's in your contract?